EB2 National Interest Waiver, understanding the second prong requirement.
Hi, greetings. I am lawyer Edwin Fogam. I have practiced immigration and other areas of the law in the United States for the past 28 years. Today, let us look at the second prong of the requirements for an EB2 National Interest Waiver. EB2 National Interest Waiver is employment-based national interest waiver, a petition that can be filed by a foreign national to circumvent the labor certification process and obtain a green card without an employer or a job offer. Under the famous Dhanasar case requirement, there are three elements or three requirements that the foreign national needs to meet or prove to obtain this benefit. The first is that their endeavor is of substantial merit and national importance. The second is that they are well positioned to advance or continue their endeavor in the United States. And the third is that, on balance, it is more beneficial to the national interest of the United States to waive the labor certification and job offer and grant them permanent residency. Now, today, let's look at the second prong. In my prior videos, I looked at the first and the third. The second prong of this requirement is that the foreign national must demonstrate that they are well positioned to continue or advance their endeavor in the United States. What does this mean? This means that they have to show that based on their education, training, experience, and background, they are in a position to continue their work. This does not mean that they have to guarantee that their work will be successful. There just has to be a reasonable expectation of success to establish this requirement. How do you prove this? There are many ways to do this. First of all, of course, your credentials, your educational credentials are important. Your work experience, your professional plans, the detailed plans, the institutional support, if you have any, expert support letters, and so on. These are documentary evidence that you can use. There are three errors that are usually made in providing this, in trying to meet this requirement. The first is that the plans are usually vague. The foreign national doesn't present a detailed, coherent, and logical plan. The second is that they tend to rely too much on the educational credentials without looking at the experience as well as the future plans and what they're going to bring. And the third is lack of documentary evidence in support of the future plans. So these are some of the things that you should consider when you are dealing with this second requirement of the Dhanasar case, that you are well positioned to continue or to advance your endeavor in the United States. I hope this was helpful to you. If you have any further questions, please do not hesitate. Call us 301-608-1555. You can also send us an email to info@fogamlaw.com. And as always, as you work and prepare for your petitions, do not fear the system. Understand it, work with it, and benefit from it. We can help you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.